Okay, good evening, ladies and gentlemen. The Stratford Zoning Commission is now open for public hearing for those petitions advertised to be heard in this session. We have a full slate of regular commissioners, so there is no alternate sitting in. I wish to announce that any items on tonight's agenda that would take more time than anticipated, this public hearing may conclude at 11 p.m. and to be continued at another date, which will be established at that time. Any items not heard by 11 p.m. tonight will be heard at the continued public hearing. For the record, petitions to be heard this evening were advertised in the Connecticut Post on October 17th and October 24th. These properties were duly posted on October 23rd. And the other thing that I would like to ask, if anybody has any cell phones or any electronic devices, if you could turn them to vibrate so as to not interfere with the speakers this evening. Ms. Phillips, if you would like to read the first petition on our agenda. I think it has 2 items.
Yes, it's 2 items under continued items. The first one is a text amendment petition of the Perkins Family Partnership, LLC, seeking to amend the zoning regulations by eliminating 3.14 regarding water bodies, water courses, wetlands, and coastal resource protection, and amend the following sections that reference the regulation. There are several of them, 8.2, 3, 5.7, then it goes on to 10.13, 14.3, 10.13, 14.42. Would you like me to do the second one since they typically go together? It's up to the applicant?
Please.
Yes. Number 2 is 1050. Wood End Road, petition of the Perkins Family Partnership, LLC, again seeking an administrative approval for a coastal site plan review and erosion sediment controls for a non-licensed motor vehicle prep and storage facility used in a MA zone. Thank you.
Good evening, Madam Commissioner, Madam Secretary, Mr. Chairman, members of the Commission. My name is Barry Knott. I'm a lawyer with the firm of Knott, & Dunn with offices at 1656 Main Street, Stratford. I'm here this evening on behalf of the Perkins Family Partnership, LLC of 1 Boston Post Road, Milford, the principal of which is Mr. Evan Perkins, who sits in the second row to my right in the black sweater. My client owns the Subaru new car dealership on the Post Road, Milford, and the Honda new car dealership on the Post Road in Westport. This is an application for zone text amendment, a CAM application, and an erosion and sediment control application for 1050 Wood End Road. Now, if this topic sounds familiar to you, it's because I appeared before you on August 29th to make a presentation on a previous zone text amendment I had submitted, which sought to completely eliminate section 3.14 of the zoning regulations and all of the zoning regulations which referred to section 3.14. You could not act on that application that evening because we were still waiting for statutorily required comments from the Planning Commission and DEP on the zone text application. However, based upon comments made by some of the commissioners at that public hearing and dialogue which occurred between me and you at that public hearing, it was felt by me that the zone text amendment I had proposed originally, which completely eliminated 3.14, was a bridge too far, and that my client's objectives with respect to the development of this property could be accommodated by a much simpler amendment to section 3.14. Based upon that conclusion, I submitted a revised amendment to section 3.14 2J on September 10th, 2018, and it is that revised zone text amendment, together with the CAM application and the erosion and sediment control application, which are before you tonight. Now, by way of recollection, I'll reference a folder of exhibits which I've just handed to each of you, to which I'll be making reference during the course of my presentation, the first 2 of which are photographs of the Lindquist Steel Company at 1050 Wood End Road, which is the subject of this application. As I mentioned to you previously, it's my client's intention to use the existing building on this property to do vehicle preparation and setup for the new cars it sells at its dealerships. All of this work will be done within the confines of the existing structure. No new additions to the building are proposed. If you look at Exhibit 3, this is the site plan, 4 or 5 pages of the site plan, which includes landscaping, erosion and sediment control, et cetera, of the proposed use. And you'll notice that on the first page of this exhibit, I highlighted in blue on the south and western side of the property is completely surrounded by tidal wetlands. That's what that blue line represents. It's tidal wetlands which completely surrounds the property on 2 sides. It is also my client's intention to clear cut some of the existing trees on the property and use excess land to store new and used vehicles owned by the 2 dealerships awaiting pre-sale preparation. Now, you're going to hear from Jeff Gordon from Codispoti Associates in a minute, who will take you through the site plan. I just wanted to point out that wetlands area. Exhibit 4 is a copy of my September 10th letter to Jay outlining my request for the revised zone text amendment. And if you look at the second page of that exhibit, you will see the revised zone text amendment, upon which I have highlighted in yellow the changes I proposed. As you can see from this exhibit, I simply added the word paved to parking areas and eliminated alteration of existing contours from the regulation. As you can see from my proposed zone text amendment, these same changes are proposed in the first paragraph and the third paragraph, exactly the same. The first paragraph deals with inland wetlands, and the third paragraph deals with tidal wetlands. The significance of this change would allow pervious surfaces to be altered within proximity to wetlands, subject to the requirements of the Stratford Inland Wetlands Regulations, the State CAM Act, and the Stratford Erosion and Sediment Control Regulations. So we were allowed to make alterations within proximity, but it doesn't mean we could just go on the site and do whatever we want. It's still subject to the Inland Wetlands Regulations, the CAM Act, and the Erosion and Sediment Control, 2 of which were here before you tonight. Now, Exhibit 5 is a copy of the existing regulation. I just wanted you to see what the existing regulation looks like. Now, at this time, before I get into the balance of my presentation, I want to introduce Jeff Gordon of Codispoti and Associates, the engineers who designed the amended site plan. And Jeff will provide you with information regarding Jay's administrative comments, the letter regarding the MS4 stormwater permit. He'll also address the drainage issues raised by John Casey and Tina Beto in their administrative comments. Jeff?
Again, my name is Jeff Gordon. I'm with Codispoti and Associates, doing business 263 Boston Post Road in the town of Orange. What I'm going to basically do is go through what changes were made in the plan in concert with the revised text amendment and response to the comments from Christina Beto and John Casey. The most significant impact is really having the 75-foot offset, which would limit us from adding any impervious pavement. We have a building that exists. We have a storage building that exists. And we were going to pave this entire area, and at one point we were looking at a type of pavement for the vehicle storage area. We have changed that to a porous material after discussions with Mr. Casey, and we have limited the area of pavement as shown here. So I have the more than 75 feet offset, and we have pavement for the ramp and existing pavement for the front of the building. Now, Ms. Beto's comments, she talked about the stormwater gallery system. The current plan is for underground galleries. And that is a pretty significant system in the main lot. And we also are adding them to the existing lot and to the existing gravel lot that is behind the building. And one of the other questions that was asked was about the need for a deep permit or Army Corps permit. There is no need for a deep permit or Army Corps. That would include a stormwater quality certification. We confirmed this with Jeff Ciola of DEEP on September 25th. Also, it's of interest to note that we're not looking for discharge off the site. We have full compensation for the stormwater in the gallery system. There is a need for always to have some sort of an overflow pipe. And one of the other comments from Ms. Beto was, were we discharging directly with a pipe into the wetlands? We do have a DOT scour hole that we're providing in the upland area before the wetlands within the confines of our property. One of our other comments was, do we need to do so much? Do we think about putting a parking structure there? That just is not prudent for what kind of use this is. Again, this is a stone lot, and one of the most important choices here is being midway between the two dealerships. There's less time on the road, there's less transport in between, so we're not bringing cars all over the place. It's a short distance south and a short distance north, so this is an ideal location midway between. She also asked about the number of vehicles and what kind of vehicles are they? Well, again, this is kind of, it changes, ebbs and flows, and this is not a junkyard. These are new vehicles, late model vehicles, maybe some are a couple of years old, off lease going for sale, but we're not talking about older vehicles with any kind of issues where they're leaking out into the pavement. She also asked about encroachment into the wetlands. There is no encroachment planned. There will be silt fence around the toe of all fill slopes. There will also be a area for topsoil stockpile, and that'll be surrounded with silt fence as well. A stormwater maintenance plan was also submitted to her, and that was part of the package of how things will be inspected, when they'll be inspected, what actions are going to be taken at various times, and that was included. Okay, the stormwater report and calculations were submitted to Mr. Casey on August 29th. One key question that he had was compliance with an MS4 feature, and we have provided that with the disconnect of stormwater runoff from the roofs and from the parking lots, and we have provided calculations to him that he apparently was satisfied with. The drainage area and the tributary area are going to be retrofitted with galleries to handle half-inch runoff and provide the disconnection from the town's drainage system. So basically, we're containing it on-site and not dumping into the town system there. He also had a question regarding building permits for retaining walls. We noted that on the plans as his request. We also added a dumpster area over here. That was something that Mr. Casey had made note of, and that has been added. And also the driveway apron at Wood End Road he wanted to be repaired. We're noting that as well. And the other question we had was to demarcate the sight lines coming out of the driveway. And we have noted that we have 800 feet to the west, 500 feet to the east, based on the 25-mile-per-hour posted speed. A tractor-trailer would have to have a minimum sight distance of 425 feet. We also made a note on the plans that shoulder vegetation along the applicant's property would be cleared and sight lines would be added. Those were added to the drawings as requested. Back to Ms. Beto's comments again. Again, we addressed the stockpile. I go to the sheet SP4, the erosion control plan. So we show this area here as a stockpile. We have silt fence around it. We're calling out for temporary vegetation. If the area is going to sit for more than 3-4 weeks, we usually hydroseed it just to get a little patina of grass on there to keep it stable. She also wanted to be sure that we're extending the silt fence around the whole back of the property, and we're doing that as well. The hay bale filters and things of that nature around the catch basins are demonstrated as well. Also out in the street, silt sacks on the existing catch basins are demonstrated. Yes, Barry?
Mr. Knott, when he had talked about the silt fence, and that's all during the construction, or are those permanent?
No, the silt fences are removed probably a month or two after construction when all the vegetation is stable.
Okay. Okay.
By the way, Jeff's response to Tina Beto's comments is in your folder as Exhibit 17. So you do have a full copy of his comments to his responses to Tina's comments, excuse me. All right, as I mentioned earlier, significant state statutes and numerous local municipal regulations already exist, the function of which is to provide the same inland wetlands and tidal wetlands, which Section 3 is to protect the same inland and tidal wetlands which Section 3.14 seeks to control. For example, inland wetlands are protected by the oversight of the Stratford Inland Wetlands Commission. Exhibit 6 is a copy of Stratford's inland wetlands regulations. As you can see from this exhibit, Stratford has in excess of 27 pages of regulations which are specifically designed to protect the integrity of inland wetlands resources within the town. Please note that I have tabbed and highlighted in yellow 2 pages of this regulation. The first tab shows the Inland Wetlands Commission's jurisdiction to be between 100 feet and 350 feet of the wetlands, depending upon what part of town you're located in. In this particular part of town, the setback is 100 feet. So anything within 100 feet of inland wetlands on Wood End Road is regulated by the Stratford Inland Wetlands Commission. The second tab refers to Section 6.1 of the regulations, which requires an application to be submitted to the Wetlands Commission before any activity can be maintained within the regulated area. So inland wetlands are protected by everything contained in Exhibit 6. Similarly, tidal wetlands are protected by the Stratford Coastal Area Management Regulations, Section 3.11 of the zoning regulations. See Exhibit 7. And the Stratford Erosion and Sediment Control Regulations, Section 3.12. See Exhibit 8. Those are the 2 zoning regulations that you are acting under tonight. One gives you jurisdiction to act on a CAM application, which is what we've applied for. The second gives you jurisdiction to act on an erosion and sediment control application, which we have also applied for. Now, Exhibit 9 is a copy of Connecticut General Statutes 22A94, which is the State CAM Act. And it is this statute by which DEP oversees all CAM applications in the state. You will note from sections A and B of this statute that this Coastal Area Management Act specifically applies to the town of Stratford, which I've highlighted in yellow. If you look at the rest of those towns all border Long Island Sound, the Housatonic River, and the Connecticut River. They're all waterfront towns. That's the jurisdiction of the CAM Act. It also covers all property within 1,000 feet from the mean high water mark in coastal waters. In other words, all tidal wetlands now covered by the zoning regulations, section 3.14, are covered by the State Coastal Area Management Act, the Town of Stratford Coastal Area Management zoning regulations, as well as the Town Erosion and Sediment Control regulations. In Stratford, for example, the CAM Act covers virtually the whole south end of town below Birdseye Street, including Lordship. That whole area from Birdseye Street to Long Island Sound is under the CAM Act. So 3.1, you don't need 3.14 to protect tidal waters in that area. For example, Section 22A-105 of the CAM Act requires all municipalities to undertake coastal site plan review. 22A-106 provides a civil penalty of up to $1,000 a day for a violation. 22A-107 requires a property owner to post a bond to guarantee completion of work. 22A-108 allows the Attorney General to institute injunction proceedings against a property owner who violates the CAM Act. Needless to say, between the Stratford Inland Wetlands Regulations, the Stratford CAM Act, the Stratford Erosion and Sediment Control, the State of Connecticut CAM Act, there is more than adequate oversight of proposed construction activity in proximity to both inland wetlands and tidal wetlands. Section 3.14 of the zoning regulation, because it prohibits any activity within 50 feet or 75 feet of wetlands, depending upon whether it's inland or tidal, prohibits, not regulates, prohibits. Because it prohibits, it gives the BZA more authority over activity near wetlands than has either the Stratford Inland Wetlands Commission as to inland wetlands or this commission and DEP as to tidal wetlands. The BZA should have more say over those things than you or the DEP or the Inland Wetlands Commission? That makes no sense. Curiously, and I went through this before, but it's very important that I do it again. I apologize for the repetition. If you look at the history of 3.14, Exhibit 10 is the regulation that was in effect in 1968. At that time, it was a flood prevention ordinance. Exhibit 11 is the same regulation that was in effect in 1987, 22 years later. At that time, it was still a flood prevention ordinance. However, and most importantly, if you look at the specific language of Section 3.14 as it was written in those old regulations, Exhibit 10 and 11, what was prohibited originally was the erection of any part of a foundation or floor, including a basement floor for dwellings within proximity to the wetlands. In other words, the old regulation prohibited impervious surfaces. Pervious surfaces were not prohibited under the old regulation, as they are now. Now, fast forward to 1991, which is Exhibit 12, and you will see that the amendment to the zoning regulations went into effect in 91 that changed 3.14 from a flood prevention regulation to a wetlands protection regulation. All of a sudden, changes of elevations were included, as well as pervious surfaces became prohibited under the new rule. Changes in elevation were not prohibited under the old rule. Pervious surfaces were not prohibited under the old rule, but now, as of 1991, both are prohibited. I don't know why. Something happened between 1987 and 1991 that caused the Zoning Commission to change 3.14. And Exhibit 12 is a copy of the new 3.14 that went into effect in 1991, and you can see the change that I just described. What happened between 87 and 91, when the new regulation went into effect, was the passage of 22A42, which was the State Enabling Act authorizing individual municipalities to set up their own inland wetlands commissions. And if you look at Exhibit 13, I've highlighted subsection C. It says, on or before July 1st, 1988, each municipality shall establish an inland wetlands agency or authorize an existing board or commission to carry out the provisions of Section 22A36 to 45, which are the inland wetlands regulations. Now, obviously what happened here is that the then zoning commission saw that another commission in Stratford was going to be created that was going to have jurisdiction over inland wetlands by virtue of the statute which I just read to you. And that zoning commission did not want to concede jurisdiction, any jurisdictional area to another body. So because there was going to be a wetlands commission that was going to deal with wetlands, the zoning commission changed 3.14. This is surmise on my part, by the way, educated surmise, but surmise nevertheless, so that they too would have jurisdiction over properties in proximity to wetlands. Unfortunately, they did it in a way which made the new regulation more restrictive on any construction activity within 50 or 75 feet. The new regulation, as I said, completely prohibited any activity within those distances, whereas the wetlands regulations, the CAM Act, and the erosion and sediment control regulations simply regulated any such activity. The other regulations regulated it. 3.14 prohibited activity. It is this prohibition under the new section 3.14 which is the problem, especially given the fact that the wetlands regulations, the CAM Act, and the erosion and sediment control regulations already provide adequate protection to the wetlands, as I have just explained to you. Exhibit 14 is a copy of the site plan of 1050 Wood End Roads, which shows two red lines around the southern and western sides of this property. The red line closest to the property line is the 75-foot setback from tidal wetlands required by section 3.14, the current section 3.14. The other more interior red line shows where on the property grading would need to be done in order to accommodate the 75-foot setback from tidal wetlands. As you can see from this exhibit, which in my opinion is a drastic exhibit, shocking exhibit, the enforcement by the town of the current zoning regulation 3.14 essentially results in a substantial portion of the parcel being rendered unusable. The sad thing is that there is no logical or justifiable reason for this to happen to the property owner because, as I cited above, more than adequate safeguards exist within the context of the existing state and local regulations. Exhibit 15 is a letter to you from DEP dated October 5th. This letter articulates certain reasons why the author is opposed to this zone text amendment. However, I have highlighted in yellow certain language in that letter which contains statements which are patently incorrect and do not reflect the status of the law in the state of Connecticut with respect to the protection of inland or tidal wetlands. At the bottom of page 1, he says, it is important to note that setback criteria set forth in section 3.14 are placed on land that is near or adjacent to wetland resource areas, both freshwater and coastal, not the wetland area itself, which is under the jurisdiction of the Inland Wetlands Commission for inland wetlands and this department in the case of tidal. I agree to that statement. He then says, the area to which the setback criteria of section 3.14 applies is therefore exclusively under the jurisdiction of the Planning and Zoning Commission. The area to which the setback criteria of section 3.14 applies is therefore exclusively under the jurisdiction of the Stratford Planning and Zoning Commission. This is absolutely incorrect. If you look at the Wetlands Regulations, Exhibit 6, you'll see Section 2.26 on page 3, which I've tabbed. That sets forth the regulated area between 100 feet and 350 feet, depending upon where you are, so that the Inland Wetlands Commission has jurisdiction over the area outside the wetlands. And on page 2, he talks about the second part of the proposed change to 3.14 would strike out the prohibition of altering existing contours of the land within the identifiable buffer area. The elimination of this prohibition would allow an individual or entity to bring in as much fill as desired to build up the contours of land parcels within the buffer areas without any restrictions. This latter conclusion is absurd. What the author of this letter is forgetting is, should this zone text amendment be approved, the importation of fill or any changes in contours to the property are still going to be subject to the application to the Zoning Commission under the CAM Act and under the Erosion and Sediment Control regulations. It's not like we can bring in all the fill we want and dump it wherever we want on the site if it's located in the CAM Act. It can't have jurisdiction. We can't do that. We got to bring it to you and show you a site plan. So he's off base with these comments. And then on page 3, he says, if the applicant believes there's a true hardship in meeting the specified setback criteria, we recommend that the applicant be encouraged to apply for a variance from the strict compliance of section 3.14. Now, here the author is suggesting that the property owner apply to the BZA for a variance if 3.14 interferes with the development of the property. Tina Beto, Stratford's Conservation Administrator, made the same suggestion in her memo of August 7th, 2018, which is my Exhibit 16. And I've highlighted in yellow Tina's comments with respect to a variance. She suggests that the answer to the applicant's need to go to within 75 or 50 feet, as the case may be, would be to apply to the BZA for a variance. She goes on to say, correct me if I'm wrong, because I'm not sure how the process of variance works. So as I indicated to you the last time when I saw that comment, I met with Tina and explained to her how the variance process works. Simply stated, an applicant may be entitled to a variance of a zoning regulation if he can prove to the Board of Zoning Appeals that a hardship exists with respect to the property subject to the application. Unfortunately, according to a long line of Connecticut cases, the hardship cannot be financial and cannot be self-created. In a situation such as we have here, the site plan we are proposing was designed by an engineer hired by the applicant, Jeff Gordon's firm. Therefore, the need for the variance would be self-created. Even if the Board of Zoning Appeals were to grant such a request for a variance, if an appeal were taken to the Superior Court by a neighbor, or a competitor, or otherwise, we would lose in court. Because in 2015, the state Supreme Court, in the E&F Associates versus Fairfield case, said that a peculiar characteristic of a piece of property which made it difficult to comply with the zoning regulations did not justify the granting of a variance when the evidence established that the property would still have economic value if the variance were denied. Here, the property would still have value if the variance was denied, albeit a significantly diminished value. Accordingly, a variance would not hold up in court under the circumstances of this case. Essentially, therefore, Section 3.14 as it currently exists completely prohibits any construction activity within 50 or 75 feet. And the court would not sustain a variance if the property had some economic value if the variance were denied. Because of this E&F case, obtaining a variance for this property that would stand up to court scrutiny is virtually impossible. This leaves the property owner, in this case the applicant, and Lindquist Steel, with no adequate remedy at law to address a situation where it does not have full use of the property due to an unfair and overreaching regulation. Even though adequate protections for the wetlands designed to be protected are otherwise available through the State CAM Act, the Stratford CAM Act regulations, the Stratford Erosion and Sediment Control regulations, and the Stratford Inland Wetlands regulations. I discussed the problem of obtaining a variance with Tina, and she was not aware of these circumstances as I've just explained them to you. She suggested that I make you aware of these circumstances when I made my presentation, which I have now done. The result of the enforcement by the town of 3.14 to zoning regulations, with no practical recourse being available to the applicant to seek a variance of this regulation, puts the property owner in a position where it has no ability to use this property in a reasonable fashion. By the way, if you look at the second paragraph of the existing section 3.14, I think it's Exhibit 5, the second paragraph, you will see that special case applications are exempt from the prohibitions of section 3.14 if an inland wetland application had been submitted for the special case use and approved by the Wetlands Commission. So why should a special case application be exempt from 3.14 and not subdivisions, or not the construction of a single-family home, or not the construction of a gravel parking lot? It's the special case applications, as you know, in this town, which are the big applications. Those are the big developments. Yet the big developments are exempt from 3.14, the middle paragraph. It's crazy. Exhibit 17, as I indicated, is a copy of the Codispoti response to Tina's comments. Now, as I mentioned above, with the submittals relative to State CAM Act, the local CAM Act, the local erosion and sediment control regulations, the local wetlands regulations, there are adequate safeguards in place sufficient to protect both inland and tidal wetlands. Additionally, the revised text amendment, which is before you this evening, contain changes which are of such a de minimis nature so as not to prejudice any natural resources, and this new language, which still prohibits on-site activity of an impervious nature, as did the old one, and this new language, which still prohibits on-site paving, such as a paved parking lot, is consistent with the prohibition against impervious structures contained in the original section 3.14, which existed prior to 1991. I would ask you to act favorably with respect to my request for a zone text amendment. The submitted text amendment is the most benign example of what I could come up with that would allow my client to develop this property in a prudent and benign fashion with all the safeguards in place under the CAM Act, your jurisdiction under the CAM Act in erosion and sediment control, so that this valuable property can be recycled into a modern and economically viable use. Thank you for your attention.
Thank you. Guess we could start with any questions from the commission. Mr. Henrik?
So, Exhibit 14, you had redlined two sections of the map.
Yeah.
If this provision, let's just say this was a special case application, then these lines, these restrictions would not be limited.
No, that's the thing.
So if you were just to call this a special case, if you wanted to use this for something that required it,
But
you
this
would.
doesn't require a
But
special
but if you did, then you would.
Well, first
you
of
could
all, that middle paragraph in that regulation that exempts special case applications
Yeah,
deals with inland wetlands,
right.
not tidal.
Okay.
These are all tidal.
Okay.
So if we were to call this a special case application, it wouldn't help this particular application because these are tidal wetlands.
Okay.
However, if it was inland wetlands,
Yeah.
we could come in with that thing you approved last month at Sydney Street. That huge project, and even though it was within 50 feet or, of an inland wetland, 3.14 wouldn't apply.
And if 3.14 isn't involved, the space beyond the red line they would still be regulated by inland wetlands?
No, on that exhibit, that exhibit, they are regulated by the CAM Act.
Yep.
And the erosion and sediment control regulations, zoning regulations, both of which we are here for tonight.
And are they, and does inland wetlands have any
No,
jurisdiction over it?
there are no inland wetlands near this property.
Okay, so is the CAM, those are, I mean, this is a line that I guess was made for whatever reason it is, but it would be still regulated by CAM, which has certain controls, and erosion, which
Correct.
has certain controls, and I'm guessing their primary intent is to protect the.
Exactly.
Wetlands?
I've included a copy of the Stratford CAM zoning regulations. I think it's exhibit 6 or 7, and the Stratford erosion and sediment control zoning regulations, both of which cover this property. And I've also enclosed a copy of the state statute authorizing the CAM jurisdiction. So you will see between the state CAM Act, the Stratford CAM zoning regulations, and the Stratford erosion and sediment control regulations, this commission, right now, tonight, has jurisdiction to make sure that this property and the wetlands that surround it are being adequately protected. That's why Jeff testified earlier. That's why he bounced this site plan on numerous occasions off of John Goucher at DEP, John Casey in our own engineering department. Originally, Casey and Goucher disagreed as to what type of surface we were going to put here. Casey wanted gravel. Goucher wanted crushed asphalt. The two of them got together and they agreed gravel is appropriate.
Okay.
So that's what we've got. So we've already got the review from the DEP and the local people, and Codispoti is the one that their engineers worked with them to get the site plan approved.
So if tonight, there's also a CAM application?
Yes,
If
sir.
we approve that, is that done, or will there be some oversight to ensure that the wetlands are
Yes,
protected?
if you look at the Exhibit 17, which is Codispoti's response to Tina's comments, attached to it is a drainage study and language relative to what needs to be done during the construction phase of the project. And essentially, what Tina wants is she wants to have a tailgate meeting on site before any construction activity begins. It's the same thing we did with the Cricket hot dog stand. That was title also. She wants to be able to go out, meet with the contractors, tell them what she wants vis-a-vis silt fencing, hay bales, and all that other stuff. And then she wants somebody to report to her on an ongoing basis as to the progress of construction.
And that's to ensure that the erosion control plan is followed?
That's primarily what she's concerned about,
Okay.
yes.
And the CAM regulations, I mean, is there some oversight on those?
Is there what?
The CAM regulations?
Yeah, well,
Or does she enforce those as well?
she enforces those as well.
So there's somebody to be on the site throughout the whole process to ensure
Absolutely.
that the things that you submit will be followed, that the inland wetlands will be protected?
You've got 8 pages of plans here that include landscaping, soil and erosion control, site plan, lighting, and then there are detail sheets at the end which actually call out what is going to be done vis-a-vis the soil and erosion control and all that other stuff. 8 pages here. And actually, I didn't give you all 8 copies in my exhibit that I handed out, but Jay's got them. Jay's got the big map.
And the plantings, I know there's a number of trees or shrubbery or trees planted around
That's
the
all,
perimeter?
that's all in the
Yeah,
landscape.
and that the intent of that is to also control some of the erosion and? I would guess,
Exactly,
yeah.
that's exactly right.
Okay.
Yeah.
So the line, I mean, the line of Stratford really doesn't, that 35-foot or whatever it was, 3.14, that prohibits, it doesn't really necessarily have any reasoning as to how or why these are protected, or?
For the life of me, I can't understand why that, I could understand if 3.14 regulated area within 50 or 75 feet.
Yeah.
Because the Wetlands Commission does, and the CAM Act does, but prohibit? There's no reason for that whatsoever.
But the laws of the regulations were probably developed with the intent to protect the wetlands?
I think that regulation was developed with intent.
No, the laws that regulate it, not the laws that restrict it, the CAM and the erosion.
Oh, yeah, absolutely. The CAM Act and the erosion and sediment control regulations of our zoning regulations were created to protect wetlands. Yes.
And, I mean, it seems like there's some scientific, I glanced through them, and it's kind of a little bit.
Well, the Stratford CAM regulation is 6 or 7 pages long. It's got a lot of detail in it.
But
That's one of your exhibits.
It's based on scientific
Yes.
knowledge as opposed to random
Yes,
lines.
absolutely.
So, okay. We had gotten something, I think, from the,
I just wanted to clarify Attorney Knott's answer, because I have a bit of a different interpretation. You asked, does DEEP have jurisdiction? Per the statutes, we're required to forward the application to them. In that sense, it's in their jurisdiction. But they cannot say, this project cannot happen. That is this board's responsibility. So, yes, it's within their jurisdiction to do a review. They give us comments, and then those comments are hopefully inform your decision. But when I heard Attorney Knott's answer that they have jurisdiction, there's just a statutory requirement for us to send it to them. It is this board's jurisdiction to say yes or no.
but do they have regulations that have been set forward?
Yes.
That say any work done in these areas, and that's, I guess, what I mean by jurisdiction. Do they have criteria laid out that say any work done in these type of areas need to be done in a specific way based on our scientific findings?
That's where our regulations are essentially taken from the Coastal Act.
Okay. So in a sense, they have a regulate, or they've created they're the body that creates the regulations for us to follow.
Exactly, and our coastal area management regulations mirror the statutes.
Okay.
Or, I'm sorry, mirror their regulations.
Okay. So in that.
Make sure that
yeah,
was clear.
And it was those regulations. that
Hold on, Commissioner Phillips has something to ask Jay.
I don't want to take away from Mr. Hendrick's questions, but it was on the same question with the Planning and Zoning Administrator, just to further clarify. Because I'm a little confused, and maybe you can help. I understand that this body is the only body that can prohibit the construction. All the other CAM, wetlands, inland wetlands, everybody else can make a recommendation. They can put some regulations in terms of how things are done. But I thought the reason why that the zoning administrator and the zoning commissioner had that power is it's the only body that can make a decision on a building and actually prohibit. Everybody else regulates, but they can't prohibit. Can you help me understand?
That's a correct assumption.
Yeah, I mean,
You're right. This is the only board that can prohibit, especially if the inland wetlands determines or the applicant is able to formulate a prudent alternative to safeguard or to basically remain consistent with the inland wetlands regulations.
So if we see that there is and I'm not picking on this application, I'm just talking about the regulation. If we see that a particular construction or building is going up that we feel is detrimental to our coastline or inland wetlands or such, there's no other body that can say no, correct? And if we remove 3.14, there's no no body that can actually say if the other bodies can meet those criteria, no.
Well, it's hard to give a finite answer to that, because you don't
Well,
know,
I
every
can.
site is somewhat specific to, every site is somewhat specific to those conditions that are there. There are certainly instances where the Inland Wetlands Commission can deny an application based on certain conditions. However, I think that the current regulation gives broader scope to this board. I think essentially what you're saying is correct. This board has the ability to say no.
We look at something,
Prohibit.
we can look at something broader and that has impact beyond just the water lines and such. We can say no. So I think there is a difference why 3.14 is there. That's my only thought. Now, I'm not reading that against this application, but I wanted to make sure that there was I had the correct understanding of why initially they had 3.14. And the BZA portion of it is because if the applicant can justify a reasonable proposal that says, yeah, this is unfairly burdened, they could go to a BZA. They could get a variance. Can't they get a variance?
Well, hold,
I'm sorry.
exactly, I was supposed to, Mr. Henrik had the floor. Mike.
I forgot where I was.
Well, I had an answer to a comment that you had made.
Okay, thank you.
You were asking about the regulations giving DEP jurisdiction in response to a comment that Jay made to the effect that DEP didn't have jurisdiction, this body has jurisdiction. You have the right to decide on a CAM application that's contrary, a decision that's contrary to what DEP recommends. You don't have to follow the DEP regulation, the recommendation. However, the point I wanted to make to you was that as far as the DEP regulations are concerned, that's what Codispoti was working with Goucher at DEP to make sure that all of the soil and erosion control, landscaping, and site plan issues relative to this particular application satisfied DEP, and it does. So it was those regulations that Jeff and Goucher from DEP were working under in coming up with this plan.
All right, I mean, I've forgotten, since I was interrupted, I've forgotten where I was, and I'll try and remember it. I'll yield the floor, I think, which is the appropriate way to go about it at this point, and allow other people to speak, and I'll try and remember where I was, but I was interrupted, so I apologize for forgetting.
Old age. Any other questions from the commission? Ms. Phillips, you all set on your answer?
No, but I did want to give the other commissions, I'll come back.
Okay.
That would be the question on clarity of the rules.
Okay, Mr. Solhavy?
Thank you. Just really one question, and you probably covered it, but at the time I wasn't looking at it so much until you got into the discussion of the regulation. I notice in the documents and whenever we're dealing with regulations, things that seem like an ordinary definition may not have their exact layman's meaning. The line that we're striking out of the regulation, or alteration of existing contours.
Yes.
Can you explain, or go over, because I'm sure you probably covered it, how we're altering the contours on the proposed development?
Well, Jeff can explain that. Jeff, would you explain?
And why it rises to the point where it needs to be removed from the statute is essentially where my line of question.
Simply stated, the elevation of this property right now is below the FEMA flood elevation, okay?
Okay.
And we are raising it to above the FEMA flood elevation because you're going to store new cars there. So we're putting in 3 or 4 feet of fill.
3 or 4 feet.
That
okay.
is an alteration of an existing contour. That's what we're talking
So the
about.
raising of an elevation of a piece of land would consider that?
That's right.
Okay.
Or lowering it.
Or lower, yeah, or lowering it. Go ahead.
Effectively, I'm adding a couple of contours because I'm elevating. But any kind of work, if I was working on a bridge and working on the bridge abutment, I'd be affecting a contour. If I was repairing an existing bridge, if I wanted to build a new bridge, if I was doing any kind of work that touched any of the ground, I'd be affecting a contour, and that technically is prohibited right now.
So how close, so that contour alteration takes place within the setback, correct?
That's right.
Okay. Okay, thank you.
Ms. Phillips, you want to?
The letter that we received from Deep on October 5th seems to suggest that they did not give a favorable recommendation and specifically said it was not consistent with their regulations. Can you talk to that?
Well, that is correct. However, if you look at the language which I highlighted in the comments I made earlier regarding this letter, the author of this document is basing his recommendation on a statement of facts which is incorrect, where he says that the last sentence on the first page, the area to which the setback criteria of section 3.14 applies is therefore exclusively under the jurisdiction of the Stratford Planning and Zoning Commission. That's not true. Between 100 and 350 feet is within the jurisdiction of the Inland Wetlands Commission, and anything within 1,000 feet is within the jurisdiction of this commission under the CAM Act and the Erosion and Sediment Control.
Okay,
So
so-
he's making a misstatement of fact there.
I get it. So Inland Wetlands has given their approval to this,
No, we didn't have to go to inland wetlands because there are no inland wetlands on this property.
or the title. So his misstatement is it's not under our jurisdiction solely, it's also under the jurisdiction of Inland Wetlands, which doesn't have jurisdiction because it's not part of that. And we've also said that we have oversight regulation from DEEP, who's recommending that we don't do this.
No.
That's why I'm asking you to clear.
What this letter you're referring to deals with is the zone text amendment,
Yes.
okay? The site plan has already been reviewed by DEEP and Codispoti. Modifications were made to it. It evolved into what you see before you.
Okay.
So from an engineering perspective, DEEP does not have a problem with this.
That's what
they
it
don't
is.
like, what they didn't like is the zone text amendment. And
Okay.
on the second page, where they talk about the elimination of the prohibition would allow for an individual or entity to bring in as much fill as desired to build up the contours within these buffer areas without any restrictions. That's absurd. We can't bring in as much fill as we want here. We got to come to you with a CAM application. And then it's got to get sent to DEP.
So if I separate the two, the application from the text amendment, and the text amendment applies all around town, then we're saying that the DEEP, just trying to get a good understanding, DEEP is not in favor of changing the text amendment because of the wide implications of it, but on the other hand, looking at this specific application, they have less issue with it.
Correct.
So we could actually deny the text amendment, you're saying, and this application would be able to go forward?
No, you can't deny the text amendment. Because if you deny the text amendment, we got to go without 75 feet. We got to go outside of 75 feet, which eliminates 40% of the parking area. All I'm asking you to do is take out the word paved from parking areas and remove the phrase changes in contours.
Okay.
That just, now it says that if you want to put an impervious surface within proximity, it's prohibited. But something that's pervious isn't, which is what the old regulation used to
Okay.
say.
Well, I understand that, but I also recognize that 3.14 affects all over town, particularly in that part of town. and we make a change to try to accommodate one application, it affects a bigger audience of
It
applications.
applies all over town, Stephanie, but you have other protections available. You've got the CAM Act and you've got the erosion and sediment control regulations, both of which are in your zoning regulations, that require the applicant to come to you in order to do anything with a piece of property.
Okay, I'm going to go with a different question, different line of questioning. If the property right now, you're saying if you don't get this approval, is the property usable by the applicant?
Not by my client, no.
Your applicant cannot use the property?
My client is a contract purchaser from Lindquist Steel. So he would lose. If you look at that exhibit that's got the red lines on it, exhibit whatever it was, he would lose, 30, 40% of the parking area.
I understand, so that would make it,
That would kill this deal, yeah,
they would kill this deal and make it unusable to
to
them?
Perkins.
Because how much parking do they need?
Well, they're bringing in cars for 2 new dealerships. I imagine they're gonna put, Mr. Perkins is here. Evan, how many cars are you gonna put on that?
350
Would you stand up
cars?
here, please? Give your name and address.
Yes, Evan Perkins, from 30 Eastern Road in Westport, Connecticut.
So about 350 cars?
Between the whole property, correct.
So if you're limited to the lines that are there by the regulation, it would reduce it, what, to half? I'm just looking at the
Probably 40%.
40%,
Yeah.
and that would,
And quite honestly, the use that we're using it for is very benign. We're lifting the property so we're above the 100-year flat level, and we're storing new Hondas and Subarus, which are pretty clean vehicles. We're not repairing cars there. We're not, on the upper
Okay.
level. We don't have trucks. We don't have, heavy equipment, any of that.
so my next question would be, given that DEEP has according to what Mr. Knott has said, may be more satisfied with the adjustments that you made with this property, wouldn't that give good justification to get a variance from BZA? Wouldn't they give that to you?
That I can answer.
He can't answer that question.
Attorney Knott can answer that question. I can.
We have to prove a hardship. The hardship can't be financial, it can't be self-created. If the BZA gives us the variance after a public hearing 2 or 3 months from now, this deal will be dead by then anyway, and we go to court and somebody appeals, we lose in court under the ENF case that I cited earlier, which says that if the property has value without the granting of the variance, the BZA can't grant the variance. It's a 2015 Supreme Court case.
Okay.
So a variance is not the answer. The answer is to make these very simple and benign changes to a regulation that shouldn't exist in the first place.
Well, I guess my other last thing is that I just established with our planning and zoning that this regulation does have some purpose that only the zoning administration can administer that the others can't. And then number 2, it kind of feels like, and I'm just putting it in plain English, that we're the easier path of eliminating everything to get this through, other than you have a really good case to present to BZA, but the risks are higher.
We
And if
don't
it's
have a good case to present to BZA. We do not have a good case to present to BZA because our hardship is self-created. We're designing the site plan that requires the variance. That's a self-created situation. We're not entitled to a variance.
so because you're not entitled
The
to.
town attorney is sitting over there. You can ask her opinion, but
Okay. I'm just, if you're not entitled to a variance, but we should provide you the ability to go forward by throwing out the regulation?
no, I'm not asking you to throw out the regulation.
Or change
I'm
it so
asking
that
you
it
to make
changes?
minor changes to the regulation so that a variance is not needed and so that this valuable property can be used in an economically feasible way, in a way that the DEP is satisfied as far as the site plan is concerned. And the fact that the DEP doesn't like the zone text amendment, I would be shocked if we got a letter saying they did like it. Because environmental agencies never like to see regulations amended.
Well, I am concerned about the environmental
Now, as far
side
as
of
your
it.
question about this being the only agency that has the jurisdiction to stop construction, you don't have the jurisdiction to stop construction under the existing regulation. You can't allow any construction under the existing regulation because there's an automatic prohibition in the existing regulation if you're within 50 or 75 feet of wetlands. So you don't have any discretion to grant or deny an application under 3.14. If they're within 75 feet, you can't approve it because there's an automatic prohibition in section 3.14, which is patently unfair. You have a prohibition rather than a regulation.
I'm going to ask the planning zoning administrator, is that correct? I mean, what's your take on this? I'm trying to understand. Mr. Knott said that we don't have, as this body, the opportunity to allow a building to move forward. We can only prohibit. There isn't any mechanism to allow a property to move forward. Can you help? What?
That's what the Zoning Board of Appeals is for.
So it's the Zoning Board of Appeals has that regulation, not the zoning
The Zoning
commission.
Board of Appeals has the authority to grant a waiver or a breaking of the rules of the zoning regulations.
Okay, I don't want to spend more time on this. I think I got a clarity in terms of the regulation, so thank you, Chairman.
Thank you. Mr. Henrik?
Found where I left off. You had mentioned something about a parking structure. Somebody had
Tina mentioned a parking structure in her administrative comments that Codispoti responded to in Exhibit 17. She suggested has the applicant looked at putting a parking garage on the property? Well, the answer is no. A parking garage is expensive, and B, a parking garage is impervious.
correct.
So it's counterproductive to what we're trying to do here.
So she's suggesting instead of an impervious structure with rainwater detention and a number of regulations that regulate the building of it, to put an impervious structure up that will
Yeah.
more than likely cause more damage to the...
Absolutely.
Okay. My last, there was the Planning Commission had a recommendation, an unfavorable recommendation, and a couple of things that I just hoping you would address that came to my attention were, it said that the proposed tax amendment may have significant and unintentional on the entire town resources. It also said that absent the proposed zoning change, you will still be able to develop the property on 3.14. And then it says that it is also based, it conflicts with the environmental goals, which is to preserve, protect, and enhance the town's environmental wetlands, blah, 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 all that. Can you just talk on how your plan will...
I was at that meeting, I heard that conclusion. I cannot disagree more with the document you just read. As far as the property being developable, should the zone text amendment be denied, you have the exhibit that shows the red lines, 40% of the property goes out the window. As far as the zone text amendment prejudicing environmentally sensitive properties throughout town, they completely overlooked the fact that you've got the Stratford Inland Wetlands Regulations, which you've got a copy of, you got the State CAM Act, which you have a copy of, you've got the local CAM regulations, which you have a copy of, and the local erosion and sediment control regulations, which you have a copy of, all of which have to be adhered to in order to develop a piece of property. So that statement is wrong.
So what you're saying is if we pass the text change, there will still be significant protections in place to protect the wetlands?
Absolutely.
And those are not random lines drawn on a map, but criteria developed through scientific research?
Absolutely.
Okay.
And codified by state and local law.
And with some oversight throughout the process?
Yes.
Okay. Okay, thank you.
Mr. Sahavi?
Just very quickly, And just to be clear, the regulation that the Planning Commission ruled on, that was the revised one?
Yes.
Okay, just want to make sure. Question through you, either to the town attorney or the planning and zoning administrator. The applicant had suggested that the reason for the change in the contour was to conform to the FEMA regulation floodplain. Would the BZA ever consider the fact that a piece of land did not conform to FEMA to be a hardship that would enable them to grant a variance?
It's a good point. You might try it. I mean, it's, in general, though, the variance, the law, especially post-ENF, makes it pretty strict that if there is another use of the property, it's either, I mean, the way variance law has developed over the years, if your neighbors don't complain, if you get the variance from the BZA, once you get to court, it's going to be overturned 80% of the time if somebody appeals it. So you're definitely extending the time and the uncertainty. But I would agree with you that that certainly is something that I would raise if I was looking for a variance and I had basically a law, the FEMA law, which is requiring me to raise the level. Understandably, because that's to stop the water, that, I would certainly use it.
I think the FEMA regulation would allow you to raise the elevation of the property.
Mm-hmm.
I don't think it would allow you to go within 75 feet, however.
Okay. Last question. So with the modification that's proposed, then the the zoning commission still has the opportunity to regulate at this point whether something, the prohibition's removed, then we still have the ability to say yes or no, correct?
I'm asking you to do it tonight on this application.
That's really the million-dollar question.
If you don't like our site plan, you can say no to the CAM application or the erosion and sediment control application. You have the right to say no to these
But I think
applications.
his point is, this isn't a special case, so do they have discretion considering
Exactly.
the language? Or is there a way to modify the language so that they would have discretion
Meaning,
with regard to particular applications?
meaning this one looks fairly straightforward, and I appreciate all the advanced work that was done by it. Let's just say one comes through here that something is more egregious than what we're contemplating here. Does this make sure that the zoning commission still has discretion? That's what I'm looking for.
I think that in some instances, no.
Okay.
I'm trying to rack my brain of an example. I'm trying to think.
You're telling me they don't have the right?
Mr. Henrik has the floor, please. No, you have the floor.
My comment was, yeah, we would have it on a campsite review.
But you wouldn't have the ability to potentially prohibit certain activities under the regulation that's proposed. You'd be boxed into what's being presented.
But they could deny what was being presented based on the campsite review and erosion and sediment control review.
I think that there might be potentials for appeals.
Come on.
No? I think you were the one
There's
who was
always-
just
there's
speaking
always-
about the chance for an appeal.
Mr. Chairman, my question was through you to the town attorney and the planning and zoning administrator. I want to make sure I understand, because there's a lot of law here, and I'm just trying to understand the practical application of it. And I mean, we're literally down to 5 words here, and I just want to be clear as to what, if in a prohibition, as was stated, I think, by the applicant, we have no control at that point. I just want to make sure that if we're going to take control or change the control structure, that the control stays within this body. That's what I'm looking for.
I would like to ask our town attorney to rule on that.
I think that's what DEP was saying.
Ms. Sullivan?
Sorry. I think that's what the DEP letter is saying somewhat inartfully. Go get a variance because we don't really have a problem with this particular application, but we don't want this, to be open season and you not to have that discretion in the future.
And this isn't going to result in open season because any application has got to come before you under the CAM regulation and the soil and erosion control regulation. And if there's inland wetlands, to the Wetlands Commission.
Very good. Thank you.
All set? Any further questions? Seeing none?
Thank you very much.
Anybody who'd like to speak in favor of this petition? Anybody in favor? Anyone in opposition? Anybody in opposition of it? Seeing none, I'll entertain a motion to close. By Mr. Hendricks, second by Mr. Vacola. All those in favor say aye. Aye. Opposed? Mr. Sulhaby, if you could read petitions 3, 4, and 5.
If I can find it, here we go. Okay, petition 2, 3, 4, and 5? Yes, okay. Petition number 3, text amendment, petition of 608 Ferry Boulevard Associates LLC, seeking to amend zoning regulations by creating a new section 29 titled Adaptive Reuse Housing Zone. Petition number 4, 608 Ferry Boulevard, petition of 608 Ferry Boulevard Associates LLC, seeking to change the zone from a CA zone to the proposed adaptive reuse housing zone. And petition number 5, 608 Ferry Boulevard, petition of 608 Ferry Boulevard Associates LLC, seeking a site plan review approval under the proposed section 29 of the zoning regulations to convert existing commercial space to a 24-unit affordable housing development pursuant to Section 8-30G of the Connecticut General Statutes on a property located in a CA zone. A coastal site plan review has also been submitted for administrative review.
Good evening.
Okay.
Good evening, Mr. Chairman, Commissioners. I'm Attorney Tim Hollister, my co-counsel Attorney Bob Rosati. Here with me, and our development team is engineer Jim Swift and architect Bob Tobin. Biagio Barone, our principal of the applicant LLC, also seated in the front row. You should have, in addition to the revised plan set, which you may have already had, but I made another copy for each of you, and then you should have a brief supplemental material package that bears the date October 18th on the cover. Since it's been 60 days since we were here, I'd like to give you a brief recap. We did make our basic presentation, received comments and questions from the Commission and the public on August 29th, and as you recall, the overall proposal is to convert an existing commercially zoned two-story structure into 24 apartments proposed under 830G of the general statutes, such that 8 of the 24 would be preserved as so-called workforce housing, roughly speaking, for households earning $42,000 to $56,000 per year, and the remaining apartments at market rents starting at over $1,100 per month. You recall we made quite a point of the fact that this is an adaptive reuse, which is good land use planning. We tried to emphasize, I will re-emphasize again, that this is a proposal to take what is essentially an eyesore, an unused building, and provide architectural, landscaping, lighting, and amenity improvements, and turn it into a positive place in the neighborhood. We do have an affordability plan which commits the applicant to very high quality materials. I think there was some concern whenever there is the word affordable housing is used that this will be inferior quality. That is absolutely not the case. There is an affordability plan where we've committed ourselves to quality materials and finishes, and Mr. Tobin talked about that. As a matter of fact, the building has an elevator because it it was a commercial structure. And as I also explained last time, following good practice under 830G, we've submitted a site-specific regulation applicable to this parcel and proposed rezoning of the subject parcel and a site plan, and then, as you heard, the administrative submission of a coastal site plan. So at the hearing on August 29th, I think it's fair to say the main focus was on parking ratio and unit mix. And on parking, the specific request was that we meet the town standard of 1.5 spaces per unit plus 10% for guest parking. In addition, even though we already met the, in the original proposal, exceeded the ITE standards, we took a second look at that. And then you'll recall that there were some two-bedroom units in the original unit mix. We were asked to take a look at that. So we've made the changes that were requested by the commission at that last hearing, added parking, revised the unit mix. So I'd like to ask first Mr. Tobin and then Mr. Swift to just review briefly the changes that we've made to the site plan and the architectural plans.
My name is Robert Tobin of Robert L. Tobin Architects of Stratford, Connecticut. We've reconfigured the apartment configurations and eliminated the two-bedroom apartments and made them larger one-bedroom apartments. This allowed us to modify our parking configuration, and that combined with site modifications by moving the dumpsters that we had located out in one of the parking spaces in under the building to an area that's further away from our neighbors, and allowed us to free up an additional space for parking. And in addition to that, we reutilized two parking spaces. In addition to that, we reutilized two existing parking spaces along Riverview Place that we will designate as visitor parking. So thus, we've upgraded our total parking to 40 spaces, which was what the town, what you were requesting at the last meeting. By initiating these two parking spaces, there were currently 6 parking spaces along here. So we've eliminated 4 of them. From a safety standpoint, we pulled the parking spaces back 80 feet from the corner, and currently they're only 30 feet away from the corner. So from a safety standpoint, this effective visitor parking can be utilized by mail and UPS and deliveries. And because as you come up the ramp or the stairs here, this is where our mail room and mail drop is for all the apartments. So it's convenient to get into for mail personnel and delivery personnel. And in the evening, these could be used as parking spaces. And these two back-out parking spaces are far enough away from the corner so they don't create a safety hazard. Plus, they are very similar to all the parking, the driveways all along the street. And as this is we're not adding all this much traffic on the street, we didn't feel that was a safety hazard. Addition to that, we did, as I said, we brought the parking into compliance with Section 12 of the zoning code. And we were also, which we hadn't mentioned before, we were also going to be installing 3 power plugs for electric cars in the parking lot under a state grant that we're looking at applying, and we meet the requirements for. In addition to that, several questions came up on the quality of the units. We wanted to emphasize the high end of the finishes in the apartments. All the kitchen cabinets and bathroom cabinets are all going to be plywood cabinetry with granite and/or quartz tops in the kitchens and bathrooms. Our kitchen appliances are all going to be Viking appliances, which we purchased under a national agreement. Every unit will have washer dryers. We'll have tile floors in the kitchens, the bathrooms, and foyers. We'll have wood plank vinyl flooring throughout the remainder of the apartments. And we'll have matching blinds in all the windows, so it won't be a hodgepodge of room finishes. And that's the end of my comments.
Good evening. My name is Jim Swift, professional engineer. Bob's covered all the site elements perfectly, and I just want to state for the record as the civil engineer that the changes that were made have no effect at all on any of the other civil engineering aspects of this, either sewer, drainage, or anything else of that nature. So they are substantially the same effect on the site. So.
Just to connect the dots, the finishes and amenities and so forth that I described are in the October 18th package that we submitted to Mr. Urbanski. And that package consists of tab 1, just a list of the things that we've just explained in terms of changes. But then the specific documents that were changed were in the proposed zoning regulation on page 3, we changed the parking standard. We eliminated the reference to 2-bedroom units, and we increased the minimum number of spaces to match your town requirements, and that's in the bold-face type on that page 3. And then in the affordability plan, which is at tab 3, we did the same thing by eliminating the reference to 2-bedroom units and otherwise republishing what we had done previously. So, Mr. Chairman, that's all we have to present tonight by way of revisions. I would like the opportunity to make some closing summary remarks as to why we believe this should be approved, but at this point I would yield to any public comment.
Okay, I guess I'll start. Unless, Mr. Henrik, would you like to? Yeah, go right ahead.
On the parking, I noticed on the nose-in parking, I guess, the 2 spaces, there's that there's that area of grass between those spaces and the parking lot. Is there any way to add 2 spaces there in addition to what you have? I don't know if it's possible or it makes sense, but in between the parking and that grass area.
If 2 more spaces could be added there?
Yeah.
Is that the question? The reason we configured it the way we did is that there's an existing ramp that comes up and around.
Okay.
And what we're trying to do is if you notice that the existing spaces do have a clear 18-foot dimension off of the street line. Mm-hmm. And so that's what we're trying to do, is we're trying to keep the full length of the 18-foot space on our private property. And if we were to try and do that here, we'd be short. We'd have spaces of 15, 16 feet in depth. Is it physically possible? Yes. Yeah.
But not practical.
Well, we'd be short.
Too short would create a danger.
Length of the space would be a little short.
Okay. All right, thank you.
Are those parking spaces, do they comply to standard, measurements?
Yeah, well, they're 18 by 20 spaces. I'm sorry, 9 by 18 spaces.
Okay,
so.
Thank you. That's what we were looking for. Anything else? All right. Well, I expected a lot bigger changes for the last month and a half that you guys have been going over. What I was listening to the public, I hear nothing about changes to the facade or anything on the entrance of the building. I didn't really feed into the theory that, people were just looking at it from I-95. Something that people who slow down for the red light on Ferry Boulevard themselves take a look at, and it just really doesn't blend into the character of the neighborhood from my opinion. Square footage on the 2-bedroom units that you reduced down to 1 bedroom appears to be they seem to be very big. Seems like to me you're setting them up so they're going to be 2-bedroom units down the road, or they could be easily converted to 2-bedroom units. not really pleased with that one. I was hoping to see some type of reduction in the units too, which would give you a lot more flexibility with the parking. Doesn't seem like you lowered any of them. You may have lowered the 2 to a 1-bedroom, but you didn't lower the actual number of units. I was hoping to see some reduction there. I was also hoping to see some type of retail put in there in place of, some of the units. I hear and see nothing of that. And I really don't see a plan on how to relieve the parking and the traffic on Riverview Place, which I know it's not your big problem, but I would hope that something would have been, thought of or brought up. You added 2 more parking spaces out on there, and if you go by there at night, there's at least 7 to 8 parking on that property now. Although it be probably unauthorized, they are parking there. You start construction, you start putting in, the esplanade that you're gonna, those people are gonna have to park somewhere also. I know that's not your problem, but they're gonna be forced to park somewhere else. Those are the changes that I was hoping to see, for me to support this project. So, anybody else with any more comments or anything else here? Mr. Sohavi?
All right, a couple questions. So walk me through parking again. In order to conform to the town's regulation, we have to include on-street parking spaces, is that correct? No. So all of the parking is on site to conform to our regulations, is that correct?
To the 1.5.
The 1.5 plus 10%. That's correct?
Correct. That's what I think that was the intention of the elimination of the two-bedroom units. That way it complies with what the base zone parking regulations are in section 12.
Okay. So how exactly it's tight, let's just say it there. So how exactly does this flow with snow removal on a site that's that dense? Anyone that wants to answer that? I'll elaborate a little bit on my question. The reason I'm concerned is that road, Riverview, is ridiculously narrow. Ferry Boulevard, it's impossible to park off-street. So if you have, and due to my familiarity with condo complexes, we have to usually sometimes they actually move cars around just to make sure that we can clear out the area. If every conceivable inch of that property is taken up by cars, there's really no place else for them to go in order to clean that lot, except probably parking somewhere on Riverview. So explain the flow, and this is consistent with what we've done with other applications, to make sure I understand how that works in a snowstorm.
Sure. The actual coverage of the site is actually less than it is right now. If you were to look at the existing survey, you'd see that the edge of the pavement goes all the way to the property line in both of these areas. So we're substantially improving the ability to push snow around just by making those changes to the site. As you mentioned, we do have a possibility that we might have to remove snow from the site. That's always a possibility if the snowfall is heaviest. But we have more places to put the snow now than we had in the past. And also point out that underneath the building, in this area, we've got this strip of area that you can see between these parking spaces that's really sort of dead space right now. And that area also can be used for snow storage if we had to push it under there to make room.
But do you have to clear out the parking lot in order to do any of this work, or is there enough room to?
Well, it's going to depend
push it
on
up against?
the magnitude of the snowstorm, when the snowstorm occurs, you know, whether folks are still at work, whether they're home.
It's a Saturday and everybody's off.
Yeah, I mean, you know, then it's no different than any other parking lot. The cars are there. They're going to have to clear the center aisle first. They're going to do that. They're going to push the snow to the end. And then they're going to maneuver. And we're in a little bit better shape than other places might be, because you should realize that this amount of the parking is covered. It's not exposed to the elements. This is underneath the building. So these spaces here, we don't have to worry about at all. And if we had to maneuver parking spaces around, and we had the cooperation, obviously, of the residents, you know, we could just push some of these cars in this way, because there's nothing physically stopping them, push them this way, take these cars underneath the building, and then clear the remaining snow. Okay. So we really don't have that large of an area to worry about for snowfall.
Go over again for me what kind of barriers we're looking at between, on the, I guess that would be the eastern side of the property, between that and the Ferry Court development.
In this direction?
Yes.
Yeah, it remains pretty much exactly the same as it is right now. It's a maintained lawn, it's a mowed lawn, and that will remain as it is. You can see that the proximity of their structure next door is on that line right there.
Okay. Would there be any objection to fencing or some type of shrubbery as an additional barrier between the two?
There would be no objection.
In the regulation itself, I hear Commissioner Fredette's concern about potential reconfiguration. There really is no room for reconfiguration in my mind. Would there be any objection to stipulation in the language that prohibits any increase in or reconfiguration of the structure to include any two-bedroom units? I notice in the regulation, the parking regulation, it specifies efficiency, one and one bedroom, but it's silent on two bedrooms. And sometimes when regulations are silent, that becomes a problem later on.
So if you're asking, Commissioner, that be a clarification of no two bedrooms, that would be fine.
No two bedrooms, and it could be any reconfiguration in that manner, or addition of, I know it specifically states 24, that's a hard number.
Yes.
So that would, okay, that answers my question.
But if you wanted to clarify that, that would be fine, because that's the intent.
Okay, thank you. No further questions, sir.
Any other questions from the commission? Mr. Henrik?
In regards to snow removal or snow plowing, I don't remember the closest building. So if you were going straight into the parking lot, straight ahead, got to the upper, what's on the paper, the upper edge of your property line, how far is the closest building from that line to the next building?
The building itself this is a 10 scale, so it's probably about 8 to 10 feet.
And I'm talking about on the other property.
Right.
Yeah.
Yeah, but in any case, we have no right to push snow into somebody else's property.
I didn't know if that's a regulation that you can't or wouldn't, or.
Well, I think they might have an issue with that if we
Okay.
push snow.
I mean, I know
against their
our
garage.
neighbors, we all blow onto our neighbor's lawn to get it off our driveway, but I didn't know if commercially. Okay, I was just curious. Thanks.
Right, and I think there's also the point should be made that, you know, we're very comfortable with the parking regulation. I think we've gone through quite a bit of presentation on how many parking spaces we feel we're actually going to need, and I think we're comfortably in excess of that. So, you know, we think we've got some space to maneuver.
Ms. Phillips, did you have something, or are you just saying you like what you hear?
I have a couple of things. Mr. Chairman had mentioned that he was expecting some additional architectural appearance, aestheticness on the building to be upgraded. I do remember we talked about that. Is there any objection or any ideas of making it look more pleasing? Is there an opportunity?
I was waiting for the opportunity to speak to that issue in reference to the chairman. and then we got barraged with a bunch of questions.
Do you want to take to it now?
If you all want me to deal with it now, I can. Sure.
Yeah, if you want to address it at this
Okay.
point, sure.
Couple issues that were brought up was the size of the large one-bedrooms. We're prepared to take and divide that space up between the two bedrooms and divide it up to other one-bedrooms, so we end up with 4 larger size one-bedrooms, which would then eliminate the ability for us to make 2 bedrooms out of them. I've got structural limitations within the building at the same columns that support the building, support it all the way through the structure. So within the limitations of the structural integrity of the building, I can make modifications to that so we can eliminate the ability for 2-bedroom apartments from a physical standpoint. And obviously, from a code standpoint, we couldn't do it because we'd have to apply for a building code and we'd have to come through zoning to do that. So that we're prepared to modify those larger one-bedrooms for that issue. In reference to the retail, again, retail is just not a viable, this is not a viable retail site. There's no real attraction other than the neighborhood, the street here on Riverview Place, that's anything within walking distance and a few condominiums. And so putting in a bodega or a deli or something like that really doesn't make sense because there's such a limited draw of people to that type of commercial. We couldn't be sticking a shoe store there or anything else. It's just not a viable retail location. So again, that's why we didn't respond to the retail. As to the parking, Mr. Hendricks had spoken about in this area here, this is a handicap ramp that's in existence there. So extending the parking down here wouldn't work with the handicapped access this way into the building and to the front entrance to the building. And again, as you noticed on our landscape plan, we were looking at putting trees in along here that would have shielded some of the building, the building from the neighborhood. And that was one of the areas that we were looking for, putting a substantial tree planting in to, reduce the size of the building by increasing the scale of the surroundings. Again, I want to emphasize that the parking complies with the town zoning regulations. I can't imagine you asking for additional parking above zoning for a project that meets the requirements, exceeds the national standards, and meets your town requirements. And additionally, Mr. Salebi, these are not considered on-street parking. This is off-street parking. So it's not, there's nothing that's going to prevent people that live in the neighborhood or people that pull up in the evening from parking here and here and across here and up to here, as they do potentially now. And they do up and down the street already. A lot of the people have modified their driveways so they're shorter because of additions and what have you. So they've self-created their own parking issue. And unfortunately, we're not here to solve that.
Right, well, they're actually parking on the property, as in the 2 parking spaces that you have added?
Yes.
They park
Oh, yeah.
at least eight.
There are
Yeah.
5 or 7 parking spaces along this side of the building before you get to this entrance, and people do use them. And unfortunately, maybe they're coming from your apartment complex because you don't have enough parking on it.
I don't think that's accurate, but okay.
Okay, anyway, we don't know where they come from.
Yeah,
but-
that was an ouch. Okay.
Anyway, as far as the architectural finishes of the building, we have looked at taking and breaking up the expanses of the stucco with horizontal, splitting up the horizontal, the large expanses of stucco with planking and vinyl, wood vinyl planking, and either introducing vertical elements of siding or horizontal bands along the windows, and modifying the window trims around the windows that would help improve the, appearance of the building and break up the expanse of the building. There's really no effort to modify the roof because, again, as I mentioned earlier, the size of the building from a structural standpoint or from a physical standpoint, it's too big of a building to make it look like a colonial structure.
Mr. Chairman, I'd like to finish my question. Thank you. If I understand you correctly, you are willing to make some architectural improvements on the outside of the aesthetics of the building, is that correct?
That's correct. That's correct.
And you will, if we should stipulate that those improvements should meet the discretion of our zoning administrator, that would be acceptable?
That would be acceptable, and we'll be, obviously present alternatives for review and.
Okay. So my next question is, deliveries, bigger vans, UPS particularly, FedEx, all of those delivery carriers, often end up parking in the street, Riverview Place. They just park there and take up all the space. We would want them to not block Riverview Place. Is that spacing that you've provided there big enough to accommodate those large vans when they do their deliveries?
Again, as we said, this is parking, well, again, with the width of the side, with the length of the sidewalk or the, to the edge of the curb, those parking spaces are deeper than 18 feet. They're closer to 20 feet, and the delivery vans for UPS and what have you could easily pull into those spaces without hanging out into the street.
Okay, and they're going to be reserved for that? They're not going to be used for any other parking?
We're looking at designating those as visitor parking, and we could also designate them as delivery during certain hours.
So the only problem I would have is that since we're tight on parking, they're going to be probably visitors, somebody's going to be in them probably most of the time, and I would be concerned that there really wouldn't be a place for a delivery truck to pull into. So I do want to express that as a concern, to say that either there is another place that they can pull into or such, but I want to make sure that delivery trucks of that nature don't need to block Riverview Place when they're making their deliveries. The second thing I want to ask, besides that, and that was a big piece of it, is there going to be designated parking for the residents so that, and this is the overall thought and concern, one, you mentioned, and the chairman has said that other people are parking there, so that we know exactly who is going to be there, that they're the residents or guests of the residents. And then second, is there going to be any kind of camera security system so that if people are using that parking space that don't belong in that property, we have a way of addressing it?
We're anticipating, having parking, people that come in and tow people that are parked illegally, and we could easily, require our tenants to have stickers and what have you, and then if we have offensive people that are parking on site that don't belong there, we can easily arrange to have them.
So if we made a stipulation that the parking spaces have to be either assigned to a tenant or that the tenants must have some identification to enable them to park there, that would be acceptable?
Absolutely.
So the only question, concern, and I don't know if they have an answer, is I do want to make sure that deliveries, and I with Amazon and everybody else and that many people, deliveries are pretty frequent now, and I'm sure that there would be a delivery at that complex probably very frequently, at least once a day, and I want to make sure that it doesn't disrupt the flow of traffic on Riverview Place.
Well, one of the things we could do would be possibly make a small curb cut here that bring the curb line back onto our property, which would allow for half a vehicle to
Kind of pull up in,
to pull up
into it.
and it wouldn't be a viable parking space, and that would possibly allow trucks to pull in, park, and then that we don't have to worry about them pulling in directly.
Pulling in there directly. Yeah, that would work. All right, that was all my questions. Thank you, Mr. Chairman.
Thank you. Any other questions from the commission? Okay, thank you. We'll open it up to the public. I'm going to ask anybody who spoke at the last hearing that it was open to, if they could let anybody, first-time speakers come ahead forward first. Anybody who would like to speak in opposition? Actually, let's go with anybody in favor of this petition first. Anyone in favor? All right, now we'll go to opposition. If you are a first-time speaker on this, please step forward.
Mr. Chairman, fellow commissioners, thank you. Ron Tickey, 2nd District Councilman, 96 Homestead Ave. I have a few concerns with this. I wish, with the limited amount of commercial property we have in our town for economic development, that there was a way to keep this commercial. Today's healthcare market, I know a little door knocking, and a lot of people are making deals with people like New Haven Health. They're setting up their medical buildings everywhere. I think it would be a fantastic environment for that. But if we are to turn this into residential, from talking to neighbors and stuff, I see this is too grand for a small space. My concerns that jump out to me is, where are the 24 U-Haul trucks throughout the year going to park and unload, A? My other concern is the trash. Currently, with the width of the street, our own town sanitation department have to stop on Ferry Boulevard and back all the way down Riverview. Now, bring their truck into the equation. I don't know how long a trash vehicle is, but pulling in the property of, I don't know who's rolling the dumpsters, whether it's the sanitation worker himself. Is that truck on the street, half on the street? So that's just a concern that came to me. I would think less amount of units, create in with the vacant space a community grand room or something for the residents themselves, some kind of recreation get-together space to kind of elevate the living experience there. As the gentleman spoke, there's not a lot to walk around. I envision, oh, let's take a nice walk through the beautiful condo complex and look at the river. But to give them a community space, I think, would kind of help just provide a better living environment. With that said, maybe eliminate, the efficiencies and just maintain one-bedroom environment. It does concern me. I was glad to hear something tonight about some work on the facade. Right now, it looks like a medical building, a commercial building. If it is going to turn over to a residential environment, is it asking too much to have the front? I understand looking at the size of the buildings, what they are, they're gonna bump out and just duplicate the windows is my assumption from the plans I saw. But give the front face a colonial look, something nautical to tie in with the condos and just the area of town. Because it's my vision for our town. We should be creating from the Devon Bridge a nicer picture than it is right now. But with that said, I just hope that, I think the plan needs more work if it's gonna stay residential, if we can't make a deal that it maintains a commercial environment. And like I said, the physical appearance on the outside concerns me. If you're not willing to invest in the appearance of the building, that just makes me question the quality of the rental property in the long term. Thank you.
Thank you. Anybody else, first-time speaker? Okay, anybody who would like to come up and hopefully have minimal, hold on, Mr. House, we have a couple speakers who would like to speak.
Good evening, Bonnie Lambert, 46 Ferry Court, Village Square Condominiums. I come here before you to renew my objections from the last meeting. I heard nothing new tonight. I hear talk of amenities. There are no amenities. What are there? Village Square has amenities, and we're concerned that these people will take advantage of our amenities. We have green space. We have a pool. We have a dock. We have a pier. We have trails to walk through our condo. We're concerned about our safety. We're concerned about our liability should people come and use our amenities and have an accident. That'll raise our liabilities, our expenses on insurance. Okay, I heard nothing new on snow removal. I heard they could move it around, they could possibly remove it. I heard no real plan. I heard a very vague explanation of what they could do. I'd like to bring your attention to something that came out of the last meeting where we talked about traffic. That's a concern of ours. They anticipate people taking the bus. If you walk out to Ferry Boulevard, you can get on a bus, but you will go to Milford Mall before you turn around and come back. So if you're going to take a bus, you have to walk under 95, cross over, and walk in front of the Home Depot and wait for a bus. What are the chances? Just saying. Okay. Aesthetics. Okay. What aesthetics? You can't put silk stockings on a pig, my grandmother used to say. Okay? I thought she was crazy, but guess what? Now that I'm older, I get it. Okay? I get that we can file these under Yeehaw or BFD, whichever you would like. Okay? They're going to put the dumpster under the building. Yeehaw. Okay? They're eliminating the 2-bedroom. Yeehaw. 2 more visitor space. Yeehaw. Okay, daily deliveries. I don't know if any of these gentlemen buy anything on Amazon or eBay or Old Navy or any of the other online retailers, but they deliver up until 8 o'clock at night. So those spaces that they anticipate being used in the evening, it's not going to happen. Okay? Deliveries come till 8 o'clock at night. I can attest to it because I work 40, 50 hours a week. I buy everything online. I know how it goes. Okay? 2 spaces for electric cars. BFD, who cares? Plywood cabinets, tile, vinyl flooring, matching blinds, silk stockings on a pig. That's all I'm saying. Okay, I hear nothing new tonight. I don't hear anything that makes this enhanced or it makes it more attractive for us to take back our objections. I'd like to enter this into the record. In addition to my objections, these are petitions signed by the members of our condo, the property abutters, for the same reasons that we brought forth at the last meeting. These are just reiterated. I do not have the signatures of everyone, but I will say for the record that everyone I talked to signed the petition. Nobody said no. Okay, their schedules and mine don't always coincide, so I can't get everybody's signature, but the people that I did are all in objection to this project the way it's being presented. Yes, please. You didn't sign it? Oh, one more, sorry.
Just out of curiosity, how many signatures are on there?
I think we might be up to 36, 40 by now. Okay, and I did miss people. People travel, people are out of town. I can only, and with my schedule, their schedule, we can only do so much. But like I said, I had no one say to me, no, I think it's a good idea. No one has said that whose door I knocked on. Thank you so much for your time.
Thank you. Anybody else who'd like to speak?
Good evening, Linda Kell, 67 Ferry Court, Village Square. I don't want to repeat what I said the last time, except I agree with what Bonnie said for the most part. I think the biggest concerns that I see is, since they haven't reduced the units, you're going to have the parking flows, the visitors, they're going to come into Village Square. We have it now with people coming off the street if they break down, whatever. So they're gonna come into Village Square, we're gonna have the police there all the time, towing cars. It's gonna be a big problem for the parking. And if you have 22, 24 units, you're probably gonna have 2 people per unit, you're gonna have visitors. I don't know about handicap parking space over there, but it's gonna be a big parking problem. And we're gonna have the cops at Village Square towing cars, getting people out of there all the time. I don't think it's gonna work. The other thing is snow removal. That's gonna be a big problem. They don't even, how are they even gonna get the snowplow trucks to get in there to maneuver and move around to remove the snow? So I really think that needs to be addressed. And the kids playing on that street. I mean, I go by there and I see the kids all the time out there. If you're gonna have UPS and Federal Express and all these other trucks, I really think that's gonna be a big safety issue for the kids over there. So those are my 3 biggest concerns. Thank you.
Thank you. Anyone else who'd like to speak in opposition?
Kerry Gleason, 150 Riverview Place. Again, not to repeat everything I said last time, my main concern is exactly what Mr. Chairman raises last time, which is what happens when people have company over. I mean, it's just not realistic to think that people aren't going to regularly have company over there, especially last time they were talking about, they picture it being younger people who are in there. Well, younger people have parties, and younger people have their friends over, and younger people whatever. So while this may comply with the town's requirements for the 1.5 parking spaces per resident or whatever, that may be anticipating or in a situation where it's a regular town street. And this goes back to the same thing that we talked about last time and that everyone else is focusing on, which is the parking and the traffic on this exceptionally narrow road. It's not a regular street where there's parking on both sides. So there's been issues now where if someone's visiting, or maybe someone's not even visiting, someone just didn't park close enough to the curb, you literally, and there's someone parked on the other side, you can't get by. You can't get by with a regular vehicle. What happens if an ambulance or something has to go by? I have an 80-year-old mother who lives with me. What happens if someone has to call an ambulance for her and the ambulance can't get down the street because there's parking that's on the street that shouldn't be there? And that's going to happen if there's this many units with this few parking spaces. You know, again, I agree with the chairman completely. The change I expected was that there would be lesser units, and therefore there would be an abundance of parkings, not only for the people who live there, but for the people who are inevitably going to come and visit there. The issue now is not only do you have, I mean, there may not be that many other people on the street as it is now. You're going to double the traffic that's on there on the street that just can't handle it because of the size of it. So that's my biggest concern, and I think most people's biggest concern on there. The snow removal, if any of that snow is going to get pushed to the end of the street, I can tell you from living there on the last driveway down, all the way on the right, the farthest one down, and there have been winters where probably a quarter to a third of my driveway is blocked off because they just can't push the snow any farther down to the end of the street because there's a metal barrier, so there's nowhere for it to go. So if they're going to be, and that's without plowing that area out. So if that area comes out and also gets pushed down toward the end of the street, it's going to create significant problems because it already has created problems for me. And then same thing that we talked about last time briefly, which is the land values. No one's calling it low-income housing, it's rent-controlled housing and whatever, but you know, there are some of us toward the end of that street, myself and the walkers, you know, where I'm paying over $15,000 a year in property taxes on that property. Having rent-controlled apartments is going to affect the land values of that street. It just is. And that's not something, obviously, that I'm happy about, and the walkers aren't far behind in terms of what they're paying, and I think that they're not going to be happy with that either. But the bigger issue is it's just too many new people in too small an area. I thought maybe there would be some more discussion about adding senior housing in. Senior housing, oftentimes, they share the vehicle, and they don't have 2 separate vehicles. They don't entertain anywhere near as much as younger people will. So I wonder why, if that's been looked at with any type of regularity. But that's basically the concerns that I would have with the project, and haven't really seen changes to address those issues. Thank you.
Thank you. Anyone else who'd like to speak in opposition?
Gary Walker, 135 Riverview Place. Even though this says 680 Ferry Boulevard, all of the troubles are going to be on Riverview Place. All of the action is going to be on Riverview Place. And just like everyone else was saying, you can't get, the UPS guy backs down and backs out. Everybody backs down. Any truck that's big backs down and backs out. And there's, where the way that the parking garage is underneath, with all those pillars, I think you've seen it, Rich, right? All the pillars underneath there, for the people, do you think that the people, if they're going to just pop in and out, that they're going to go underneath there and go through all that pillars and that maze to get to their spot? I doubt it. They're going to stop on the street, do their business, bring their stuff into the house, and take off again. So it's really, it's so much of a Riverview Place problem, more so than anywhere else. If there was an entrance to that alongside your condominiums there, where they could go in and go into that garage, it would be a totally different story. And like they said, they didn't cut down the number of units at all. The revised plan is really, it's not, it's the same plan. And that plan was unacceptable. And I believe you have to make a zoning change to accommodate that, a spot zoning change, am I correct? And if you have to make a zoning change for something, I'd make it for something a lot better than this, a lot more worthwhile. So I hope that you know, don't approve it as it is, I hope. Thank you.
Thank you. Anyone else who'd like to speak in opposition?
Good evening, Barbara Dugan, 63 Ferry Court, Village Square condos. Again, I'd like to address the same thing I did last time, besides the parking and the snow removal and the fact that the street is way too thin. For me, the elephant in the room is always Raymark. What is across the street from this? Right? Hazardous waste. It's everywhere in town. There's undetected places that they don't even know where it is. So I went to the health department and I asked them, has this piece of property ever been tested? And I was told, no, we don't have to test it. And I said, why? We just don't need to. And I thought, well, we're going to move people into this house, and apartments, many people, who could be exposed to these VOCs, as well as trichloroethylene, dichloroethylene, both synthetic toxins used to degrease the brake pads and the machines they used. In World War I and World War II, they made brake pads for tanks there, correct? It was there for 70 years. That's a long time to be dumping toxins into the ground. There's a huge groundwater plume of toxins underneath the property in the area. Many of the houses surrounding have venting systems. We don't know where these toxins are now. We don't know how fast the plume is moving. Where we live, it's fine. We've been tested. But in good conscience, can we put people here without investigating this? I say the answer is no. I say we go for some sort of a business there, people that aren't going to live there 24/7. I don't want my children or anyone else's children living in an environment that could be unhealthy, possibly causing cancer. We all know about the little girl that lived on one of those streets and what happened to her, right? So let's ask ourselves, before we put people in harm's way, have we done due diligence and investigated whether this is a safe property or not? That's my question. I couldn't live with myself.
Thank you. Anyone else would like to speak in opposition? Anyone else in opposition?
Carol Walker, 135 Riverview Place. And we've talked about everything. The only thing I want to say is I think it's very nice that he said that they would make sure that they had parking stickers for the people who lived in these apartments. What about for us? What about for the people that live in the apartments parking on our street? That we don't have enough room as it is. It's a dangerous situation for ambulances and any fire trucks that need to get down the street without having extra parking, people parked on the street. And if you look at I hope you've looked at where they're calling the parking area, because with all those pillars, there is no way that people can park inside there and get in and out the way they claim that they can. Please go over there if you haven't and take a look at it, and you'll see that those parking spaces don't exist. Thank you.
Thank you. Anyone else who'd like to speak in opposition? Anyone else? Seeing none, I'll take a motion to close this petition. Mr. Solhavy, second by Ms. Phillips. All those in favor? I'm sorry. Can we withdraw that? Yes.
I was going to try not to talk, Mr. Chairman.
Trying to get us out of here before midnight, that's all.
Attorney Robert Rosati, 3241 Main Street, Stratford, Connecticut. The last speaker raised the asbestos issue last time, and she did it again this time. And if you simply go on our website and the Health Department website, you can see a map that's part of the Raymark file, and I'm going to submit that. There's additional properties. I think there's 22 additional properties that are considered Raymark sites. They're highlighted in yellow. 608 Ferry Boulevard is not a Raymark site. The answer to her question is no, it's not a Raymark site. The property has been tested. DEP came out and tested it. Air samples were found to not be a problem. The soil gas is acceptable levels of the EPA. I'd like to submit that. So this property is not a asbestos problem. What has to happen is, like the whole neighborhood, the subslab depressurization system has to be put in if we're going to do residential instead of commercial. We knew that when we acquired the property. My client's not stupid. Most of the time, I'm not stupid. We researched this. The whole area, the EPA came out and offered these systems. We know now that we're converting to residential that we have to do this system. End the story with asbestos. It's not an issue. Also on that website, our town website, is the maps that show our property in relation to all the residential properties that have these sub-slab systems. It's an enhanced radon system. That's all it is. That's all it is. So I'd like to submit the first figure, Exhibit E3 from the Raymark study from September 2006. It shows that we're just outside the commercial area, but we are within, part of it's within the residential area, which just means we have to do the sub-slab enhanced radon system, which is what we're committing to do. And again, that can easily have been found by anybody on our health department and our town website. Thank you.
Before you go, I have one more question I'd like to ask our town attorney there. Is there any way that this board can hold them to a certain price in the rental of those units? Can we put something in a stipulation of any sort?
Well, they'll submit an affordability plan. I don't know if that's been done. That would give them, would restrict them.
If you mean the maximum qualifying income, that is in the affordability plan.
What the concern that I've been hearing an awful lot of is the affordable housing applicant, shall we say, that's gonna come before you guys for a rental there. And again, I'm gonna revert back to one of our previous meetings where you had said that it was gonna be $800 a month for the rent. And unfortunately, that seems very, very low, and, you know, the caliber of
Well, that's
renter may be in question.
That is 4 units, and that's also without utilities. Then there's 4 units that are at a restricted rent, but at a higher level, and there's 16 units that are at market. And by the way, when I said 1,100 for the market rates, that's the minimum. The target is going to be 1,700 to 1,800. So, and these are all mixed in. You won't be able to tell which, as you stand at the doorway, which is an affordable unit, which isn't. They're intermixed and spread out. And the finishes and amenities are identical for every apartment. So it's, you know, if you're thinking that there's a area of the building that's stigmatized with lower rents and lower quality, that's not the way these are built.
No, I'm sure you're not gonna, you know, separate that in the building, but, you know, you're gonna, you know, be inviting into, for the application. And the concern is anything under $1,500 a month rent is gonna be of, you know, major concern.
Well, there is an enforcement mechanism in that there's a required annual filing, so the town will be apprised of the, without names, but with the income of the qualifying tenants, and there's a compliance certificate that needs to get filed every year. So you do have oversight, you do have control to make sure. Now, if your question is, can we stipulate to a minimum rent for the market rate units, the answer is no, but, I mean, that would be a price control, but, you know, the economic model of this type of development is, it's really the market rate rents that support the ability to have some workforce units in the building. That's how these are privately financed.
Yeah, I believe that's how the question was proposed to me, if you could have a control of the minimum amount.
Well, you do have control over the affordable units, but the rest, I would say, really, it's self-enforcing, because Mr. Barone's going to have to go to a bank and show them an income stream, and they're going to have to agree to what it is. So, okay.
Okay, if you'd like to wrap it up.
Okay, I will, thank you. Let me first just comment on 2 aspects of the overall site plan. With all due respect, at this point, parking should be off the table as an issue. We exceed the national standard, we meet the town standard, we added parking spaces. We'll certainly will accept Commissioner Phillips' suggestion that there be a parking permit system. We can agree to have signage on the street so that there's no unauthorized parking. Some may say, oh, people are going to do it anyway. Well, we're entitled as an applicant to a presumption that people will follow the law, and if signs are posted for unauthorized parking, that they will be followed. You know, we always hear the neighbors on the traffic issue, but the evidence is that there are 7 trips at the peak hour out and 9 at the peak hour in. That's 1 trip every 8 minutes. This is not a traffic generator by any stretch of the imagination. There is no change in the levels of service at the intersection of Ferry Boulevard and Riverview. There's no evidence at all of a safety concern. And again, with all due respect to the neighbors, there's just a little bit of a head scratcher here. The street is narrow, but it's okay for those who live further down the street, but it's not okay for where the building is that we're talking about. You know, there's just a little bit of a disconnect here. And then remember, please, that the comparison is a commercial or retail use, which is what this was proposed for, even a religious use at one point. But you can't compare a vacant building to what the neighbors would like to see. So I think we have done our job on the parking and on the traffic. You know, as far as the architectural, you know, again, we will accept Commissioner Phillips's suggestion that there be a final round of an architectural review to the satisfaction of the zoning administrator. That's fine. If the commission wants to ask us to look at the feasibility of a pullback a part of the sidewalk so that there's a small portion there for delivery trucks. But I would emphasize, you know, delivery trucks are only there for a matter of minutes, and it just everywhere that delivery trucks roam, you know, they try not to disrupt traffic, and if they do, somebody calls them on it and they don't do it again. So that, I mean, that's just the reality. So let's not assume things are worse than they are. So in closing, I'm just going to ask or remind you that you have 3 applications, and you should, and I believe Attorney Sullivan would agree, you should take a separate vote on the regulation, the rezoning, and the site plan. The 830G standard, again, I'm not going to beat you over the head with it, but you recall that your obligation is to approve the application unless there is clear evidence of a public health or safety reason for doing so that clearly outweighs Stratford's need for additional workforce housing. This is adaptive reuse. That is a good thing in any community. You will improve the appearance of an eyesore. Not that it matters legally, but with all one-bedroom and efficiencies now, there will be virtually no school-age children in this building. That just, you never see them in a one-bedroom unit. And the rents, as we say, are divided within workforce housing and market rate housing. So we think this will be a positive addition to the town's housing stock. I want to thank Mr. Urbanski for his help in getting us to the public hearing and through the application process, and I want to thank the commissioners for listening to our presentation. Thank you.
Thank you. Anything else from the commission? We're all good. Mr. Henrik?
And it's just a thought. I was in New Haven the other day, and I don't know if it's realistic, but I was in New Haven the other day. New Haven has certain streets zoned as neighborhood parking only. You have to have a sticker. I don't know if that's something that Riverview can do. You know, if you own a house, signs up that say...
The street as a whole?
Yeah, the street as a whole for...
That's up to the traffic authority. But
I don't know if it's just a thought, but... Yeah.
The applicant would participate in that.
Yeah.
Okay. Motion to close by Mr. Solhavy, second by Ms. Phillips. All in favor, say aye. Opposed? So moved. And if Mr. Vacola could read... okay, yeah, go ahead. We're going to take a 2-minute break for a minute.